right, welcome back to Kivumbi 2022, and of course this is the hour that we have a discussion. And when you're speaking with the lawyers, you have to carry this, the Bible, the lawyers, the Constitution, because tonight every reference might just come out of this. And tonight I'm joined by three advocates, practicing advocates of the High Court of Kenya. I have Gibson Gisore, first time on the show, right? First time with me on the show, but I've seen you in other media outlets.
Sure,
you're doing good. Thank you so much for coming tonight. And of course, Peter and Njagi, my friend, how did it go with the elections?
The yellow fever swept us.
What an excuse. Was it yellow fever? But you did well, I have to say. You did well, and I saw you. Was that concession speech?
No, it was a Thanksgiving speech.
Thanks, Wakili and Dr. Komolo.
Yes.
Thank you for coming back. And you're sitting right here, the last time you were here.
Yes.
All right.
Thank you.
So thank you, gentlemen, for coming. There's no lady tonight on the table, but let me begin the discussion tonight by asking an obvious question. In 2017, after the nullification of that election, the current Azimio crop, right? Azimio incarnates, they did not want to go into the repeat election with Wafula Chebukati. I mean, I was at the Supreme Court and James Orengo Sr. was at the Supreme Court, and one of the things I remember James Orengo saying, now we will pursue Wafula Chebukati. And nothing happened. Dr. What happened then? How did they end up ensuring that the 6 years of Wafula Chebukati was secure? Because he just got into that position and it took another 5 years to handle this election.
Well, IBC commissioners are state officers, so there's a very clear procedure for removing them from office if they don't resign voluntarily, and that has to be followed even if you disagree with Mr. Chebukati. So I think what must have happened in 2017, 2018 is that first nobody individually followed Mr. Chebukati petition for his removal, and two, I think you have to then appreciate the import of the handshake.
Okay.
That then lowered political temperatures, and in the process, we got into BBI and things like that. So people got distracted. But the fact that we are facing another petition filed today, and the fact that Mr. Chebukati seems to be in the eye of the storm, means that we probably need to have a conversation about whether he should ideally preside over another election, should the court order for fresh elections.
Wakili Njagi, this is a little too late in time. I mean, if they saw it, the reason why I'm bringing this right at the top is because one of the prayers that Azimio have is for Chebukati to be found to have misconducted himself professionally as the chairman of IBC. In other words, they're still putting his character right before the court, right? So that's the reason why I'm bringing it. I mean, is it a little too late for them? I mean, he has 4 months to go.
I hold a contrary view than Daktari, and I think I'm seized of the application that was filed today. And if you look at the substance of that application, it not only goes to the character and the person of the chairman, but it also imputes criminal culpability. And those are very weighty grounds, especially to a state officer holding the high office of an IBC chairperson. And remember, when you impute criminal culpability, this is a question that also borders on rights and freedoms, which may be curtailed if you're found culpable or if you're pronounced guilty. So that the question should be, how then do we sustain those kind of charges if indeed there are electoral offenses that are penal in nature? And the test applicable is a test of beyond reasonable doubt, because it's a question about criminal culpability which is higher than in a civil matter which talks about balance of probability. And I think the framers of that application, I think they are well represented, but it's also good that we should also be seized of the response or the rebuttal thereat. But in a quick response to that, two issues that I could maybe pinpoint. The Director of Public Prosecution is the one that is mandated to carry out and prosecute criminal conduct or criminal culpability. But in event that he is not doing his task or he lacks on the same, I think if the Azimio team is of the considered view that criminal sanctions apply, then they can pursue through private prosecution proceedings, so that also we can bring sanity to our institutions.
You've really gone ahead, Wakili, because one, finding a criminal culpability of Wafula Chebukati or otherwise is not a subject that is before the court.
It is because they have imputed that the conduct that he actually conducted, they call it a criminal enterprise. And a criminal enterprise shows you organized crime. So essentially, he was furthering a criminal purpose, which now begs the question is, how then do you sustain that in a criminal process, notwithstanding the petition before?
Are you saying that the Supreme Court might decide to pursue that in this petition?
The Supreme Court is not ceased to hear and determine.
So it's irrelevant.
Process. It is relevant on two questions, because it can give a finding which can now bring a bearing if such proceedings.
For example, nullification of the election.
Yes, and actually, if it actually also pronounces or finds that criminal sanctions should be should actually lie on that particular individual.
Can they do that?
They can give a finding which now would guide a magistrate court if they want to pursue that.
But you will still have to go to the DCI first before they recommend to the DPP.
The finding has a direct nexus on how among the prayers that are being sought. And
all
I
right,
think
we'll talk about that in details because we'll look at some of them. Wakili, talk to me. Do you think it's a little too late? If, with hindsight, what was supposed to happen in 2017? Were we supposed to go after people who are deemed to have committed electoral offences?
Yes, I think from where I stand, we should have. We should have done that so that we shouldn't be able to find ourselves in this particular situation. But the fact now we actually didn't do that, we let Chebukati to stay on a little too long, then this has happened. So I guess that bringing criminal culpability at this particular point for the Azimio side is just trying to already muddy the waters and try to give impetus to their petition, which I guess, of course, it's a good thing. It's a good thing if you look at it from one perspective. But then they are trying to bring in the aspect which Wakili has said that it's a criminal enterprise. But if you claim it's a criminal enterprise, then an enterprise is worth more than one person. So it means the whole IBC is rotted because the fish rots from the head.
Indeed, all of them have been sued.
Yes, so, and then the law is very clear for somebody who actually was been, especially in electoral offences, they ought to be prosecuted. We have seen some low-level officials being prosecuted. I think pockets are across the country, some people have been prosecuted. So the chairman is not immune. Once he's not immune, then we should be able to see if Azimio actually produces the evidence to show that he was really involved, then the DCI should be able to jump into action, investigate this to the very end, because that is a very sensitive office to have somebody running a criminal enterprise, and we should be able to see justice.
Looking at the pleadings, it is the first time, I don't remember, gentlemen, any other court that has subpoenaed the DCI, because they're looking for evidence. The Venezuelans are back, you know, all those items that were in the country, the laptops there. They really want everything that they're able to get. So this is the first petition, in my opinion, that they're going for the criminal aspect of what happened. And it's possible that they could use that, and as he says. But I want to ask this to Dr. Komolo. There's precedence in this. In terms of was Hassan, what was his name? The predecessor of
Isaac Hassan.
Yeah. They were removed. So when you say they have a constitutional protection, right? It doesn't mean that it cannot be done.
It can be done. Isaac Hassan was not removed. There was a negotiation, and then they resigned. And then they were
technically speaking, you are explaining what happened, but there was activism. They wanted them out. That's the reality.
That's why I'm saying that removing Chebukati is not that difficult. Once there's political consensus that he is presided over very fraudulent elections, and the substance you see in the petition are things that are actually backed by evidence. Some of them will come out during the hearing. So to me, it's very clear in my mind that we cannot have Mr. Chebukati preside over fresh elections, and a conversation should already be going on when he's leaving office, either through voluntary resignation or at a more practical level, since he has about 4 months to go, and the fresh elections, if they are ordered, will be somewhere in mid-November. So at a more practical level, you can also take terminal leave to proceed 60 days before end of his term, so that we have a different person preside over the elections and cleans up.
Dr. Komolo, you've already concluded this petition.
I have not concluded the
You
petition.
have. He has concluded.
I have. No. Let me clarify. I have not concluded the petition. But I have interacted with the evidence.
Yes.
Slightly more detail probably than my colleagues here, and I'm consciously waiting to see how Kenya Kwanza will rebut. And from there, we will be here to discuss. I'm very convinced. I'm very convinced that something has to happen.
Something will happen. Something will give.
I'm very sure about that.
you know, the reading of the application that was filed today and the 2017 one, there is a systematic pattern of being consistently inconsistent of the applicant on two fronts. Upon a pronouncement of such kind of an election, it behooves the candidates and the institution to be beyond the personality. But if you look at that application, and you've talked very, very rightfully, you cannot come to court and ask the court, assist me to get the evidence. You come to court because you are of the considered view that you have an application which is triable and which has high chances of success. But when you try to subpoena and tell us, on the 21st of July 2022, Gustavo and two others were in the country, can you tell us, bring that evidence so that you can assist in prosecuting this matter? I think that's a very basic tenet of law, that you present a case because you have the view that you have triable issues for determination. Because we practice what we call adversarial practice of law. We are not in a French system whereby we are in an inquisitorial system whereby the courts now becomes like an inquiring court. But as a quick rejoinder, in terms of not even having the privity of looking at the rebuttal from the sued parties, on the face of it, there is some test that is applicable for purposes of sustaining the prayers that are being sought. And the concern, I think, to the viewer and to any Kenyan of goodwill should be, should we then personalize the institution so that then, because the basic rule of law, he who alleges must prove. So if you're really talking about the culpability of the chairman, and I'm not holding his brief in any way, but I need also to make it very clear, he who alleges must prove is a cardinal rule of law, so that if you're alleging such kind of culpability lies, then at least you have something cogent to present to court, but not...
I know what you want to say.
Yeah, I just want to confirm that the petition is not a fishing expedition for evidence.
Obviously, we don't expect you to say less.
The 2-3 incidences where we are seeking to have DCI director produce some information are live cases that are already under investigation, the Venezuelans and the other aspect that I'm forgetting here. But so we are not really seeking anything new. There are things we already know. There are things we know they are in custody of the DCI.
Okay.
And even if they don't produce them, the petition still has enough evidence.
But is there a way the court can force them to produce?
It's standard practice that we go through all along, that if there is an official entity that has evidence or additional material that could help the court to arrive at a just decision, then you make an application. We summon police officers to come.
And that
we do this all the time.
No, but you see, my confusion with this is that, and I'll bring this to you, this is a very timed process, 7 days within which they must submit these documents to court. That is today, make the application, and then 14 days of which it must be determined. There are processes, there's conference, status conference, all that, all through. So they're basically busy, their hands are tied.
Yes.
What you're asking is a lot that will take them out of the comfort of 14 days, which, by the way, Supreme Court has argued that is a very short time.
Can also come in? It's good Daktari is telling us that they have cogent evidence to prove their case other than the one they were expecting from the DCI, because that would be rather absurd if they were expecting that to be the main backbone of their case.
Why would it be absurd?
It's not the main backbone. What we are seeing are the computers that were confiscated.
Okay.
And normally you have an IT expert to then verify that. It's very basic things.
Okay.
Yeah. And DCI is a public institution, so they have an obligation to assist the courts.
Okay.
Yes. So what I was looking at is the aspect that this, as you have said, it's a very timed process. So what I would expect is for them to go specifically to the key areas which they think this election must have faltered, or the culpability of specific individuals. If they go for Chebukati, they should be having cogent evidence to that effect, so that we don't get to see a situation whereby you're saying we're going for Chebukati, but we want DCI to bring the evidence so that we prosecute him, so that the court assists the court to. That might take time. Okay. So if we are going to look at some of these issues, the petition must have been very clear. We engage in very slim issues which are very clear, so that we end up having a very good determination from the court.
That would be a preserve of the court to fashion the issues that are going to be determined, because we have 9 petitions apart from the one from Moses Kuria.
If I might take you back, the 2017 petition, you remember, there was an issue of the server. There was an application before the court to have the server opened. It was never opened to the very last minute. If you go back to the 2013 one, you do remember the issue of the 900-page affidavit, which came in too late. So there's a tendency which the petitioner seems to be trying to keep the court busy on things which are not very pregnant, which they are very sure of that they actually should have looked for other evidence to prove their case, but they keep digging further and further, so that I think the court is going to be overwhelmed with all the petitions that are in place.
Let me ask you. There's the application stage. I think it's the stage 4, if I'm not wrong. The application stage, they'll deal with all this. They'll ask for those things, right? I mean, what he's asking will still be raised on the floor that day.
It will. That's on the 8th day during the status conference.
The status conference. Okay, you've taken into totality.
It's normal that applications will be made, including by the respondent.
And by that time, they shall have known the content of your petition.
Those ones will be determined. But remember, there will be some key issues which will be spilling over into the hearings. And some people will still be saying, I still want time. If you limit the issues, then there will be enough time for the key issues to be deliberated. You saw the BBI aspect.
We've even framed the questions in already the petition. We are very clear. On
with you only in
the questions that we need to be addressed. The Kenya Kwanza side also has a right to frame their questions, and that's why we have a status conference. Importantly, the application of DCI, I don't want this to become unnecessarily controversial.
Okay.
There's a main ground allegation in the petition that the server was compromised. And part of the people who compromised the server are these Venezuelans. And we also have other details about people who are hired to do this. So part of DCI investigation was to see which kind of details, credentials that these people had, and what role they did. So they did in trying to compromise the server. That you see is very clear on the petition. So it's also a very serious thing. It's not a very big thing that we need from them. We actually need to know their role in the IT system.
Okay.
And how they were brought on board.
I saw something about forensic audit of those computers and flash disks. Okay.
And remember even, was it KPMG also had audited IBC processes, and on 2 occasions they confirmed that there are unauthorized persons accessing IBC data and all that. So it's a very straightforward thing.
Okay.
I can assure you that DCI will have no reason not to give.
Okay.
And I can assure you Kenya Kwanza should have no reason to worry if they know that this is clear, that they are not involved in this.
Njagi, how far back do we go with this case? Because if you look at the processes that needed to have been complied with, the Elections Act and all those things, they are blatant disregard to the laws, for example. And I can quote them, Section 44, right? You can say you need procuring of the electoral technology and all those things. So how far back can they push? And there's an argument that if they are able to push far back to months before the elections and the issues they did not comply with, which are in legislations, then this analytic ab initio. How far back does it go? Does it start on the day of the pronouncement, on the day of the real voting, the 9th of August? Where does it start?
I think the courts have pronounced themselves on that question, that election is about the process, not the event. So in as much as you look at the outcome or the pronouncement that is done by the returning officer, either at the parliamentary level, the governorship, also not, or for purposes of today's discussion, the returning officer who is a chief, who is a chairperson of IBC at presidential level, it has to be looked at the entire processes from the question about procurement, and it should be compliant with Article 81 of the Constitution, which gives a threshold of a free, fair, and verifiable election. And interpretation have also been found in terms of what amounts to a free, fair, verifiable, and a simple election. If you look back in the question about IEBC versus Maina Kiai case, I think the court also gave guidelines on how a free and fair election should be, that the duty of the national returning officer is hinged on the results that are found from the polling station. So that now the question about transferring the votes, and actually whereby there was an element which can give rise to a mischief, was cured to the extent that the presiding officer at the polling station, whatever he records there, is actually what now should be pronounced at the National Tallying Center. But I'm over, as a scholar and I think as a leader of thought, I think we should also ask ourselves, when you talk about verifying those kind of questions, that is where you talk about 34B being delivered for purposes of confirming the authenticity or otherwise of that document. Because now the question that should be before us is, in event whatever has been pronounced by the presiding officer at the polling station, you as a chairman find a disparity. Do you have a leverage or do you have a discretion to either vary or maybe seek better particulars to that extent? Or is your work reduced to pronouncement of whatever has been delivered? Because then it beats the question about verifiability. And I think those are the issues that should be addressed and should be looked at in a very broad and deep manner.
So where does it start, Wakili? You've lost me. How far back will they go with this? Because you brought us to 34A. That's the finality of this process, sort of.
I think Gibson said it very clearly. What he fell short of telling us is that this application is everywhere. The 72 application is everywhere. Okay. Because they talk about the Gustavo and two others, the Venezuelans. They move ahead and talk about the DCI. So to answer your question straight up, the law has been settled. It matters not how you get evidence, even if it is still admissible, because that's our practice. But you don't come to court and tell the court, assist me to get to that particular evidence. Listen. And when he talks about the question about the DCI, remember the DCI is not a party in this particular case. And you also have the right of reply. They may also want to give their side of the version because... But they could. Remember there's a stage that we have the friends of the court. They could be. As an amicus, who come as a friend of the court, is to assist for the court to arrive at a just and informed decision. And could they just come and say, as DCI, we're coming as friends of the court to aid the court in arriving at that particular answer that you're looking for, and as friends of the court, we arrested these people.
DCI doesn't have to be a friend of the court.
No, he's just saying that they're not part of this process.
Yes, but it is common practice that you can seek specific orders to compel state officers to produce some evidence. I don't know. I actually don't understand why this is controversial, because we know what DCI has been doing during the elections, and we know that they are in possession of some information.
The controversy is you are using the court, or Azimio is going to use the court, right, to obtain evidence instead of coming with evidence to court.
That is literally mischaracterization. You remember we went there with the evidence full in a lorry.
We don't know what, even if the boxes were empty. We're not sure.
No, but I was there. I can confirm to you.
It's about the quality of the evidence, not the quantity.
The quality of the evidence will be interrogated by the judges. Give us time to present.
Okay.
What I can assure is that that's a limited application that we are seeking to get some information from DCI that's already in their possession.
That you can do without.
Yes, and just to help my brother, the entire election, that the issue of process and event was settled by the Supreme Court. So we are actually auditing the entire election process from procurement. Remember, you will see this later. Remember, we will have evidence our Form 34A was altered with two different serial numbers. Details that I can't discuss here because we should not be discussing.
We are still like we have a window.
But that is already speaking to you about procurement of the entire IBC infrastructure that supported the election. So we are not talking about Form 34 at the tail end. Okay. We are talking about auditing the entire process, and that's why we call it a criminal enterprise.
Well, you said I wanted to ask if KPMG is part of the case. Wakili, go ahead now.
The qualitative analysis should be looked vis-a-vis the quantitative thing that that we are meant to, that intimidated all of us.
In
terms of the
2017.
the evidence that came today, and you said it very correctly. 10-foot lorry.
Was it? No, it wasn't. It was a lorry, nonetheless.
Probably 8-ton lorry, but it was a lorry. Yes.
It was a big vehicle. Let's put it that way. When I look at it, Ken, in a very holistic way, everybody wants to lose, but lose fairly. Nobody's saying that I have to win. You remember, I've been also be a candidate, and the cardinal rule is that you also want to go to a match whereby the referee is like Caesar's wife, should be beyond reproach. And I think that is a tenet for any common practice, because what is good for the goose is also good for the gander. Remember, tomorrow it can be the other way. It can be the other way around. So, in terms of the arbiter who is sitting in this particular exercise, who is the chairperson and his commissioners, they should hold the office in high regard in terms of attaining that particular question about having that, not only the legal legitimacy, but also the public perception, which I think is something that we should address. Quality of the evidence that was brought today would also be looked into when you have the rebuttal from Kenya Kwanza, so that now we will be able to weigh in a weighing scale how the question is, and also not being at the risk of being sub judice, but just
I think we still have time.
Having looked at it. But on the face of it, I'm of the very considered view that the application was within their rights, but that application also has to be looked in terms of the specificity of the prayers that the court would wish to be looked into.
Okay.
What I think I can say in regards to this, Dr. Komoro has said he has interacted with the evidence and he has tried to defend the petition as much. And what is of interest to me is the fact that he is actually saying that for him, these things will later be framed into issues. So they have thrown everything around there so that at the end of the day, they will now narrow down to these issues. So at the point when we will be having these issues, I think they will be able to be shaped clearly so that they can now say, this is clearly what we want, 1, 2, 3, and this is how we want it. This is what we are serving. So these other issues, of course, Wakili is saying 10-foot lorry evidence. They will have to stick to the key cogent evidence, and that one will be able to, so that the court will have enough time to actually canvass whatever it is that they can be able to canvass within the limited period of time. And that is very interesting. The other aspect is the issue of raising the Venezuela. Those issues came before. So if you want us to audit the whole entire process from where it started up to now, I think already this year we're already seized of the issue, and they should be left to run with it and prosecute whoever it is that was responsible for that, because it's a matter of public domain. Putting it as part of their petition really, I think, is kind of trying to stretch it too far. What I would have expected their petition to anticipate is the aspect that this is what Chebukati did wrong. He ended up declaring something which he was not supposed to declare. So we have this evidence to this effect. Kindly find it that he did wrong, and let's if it's going for an election, let's go for another election. Okay. But then again, it also comes, they're saying now we don't want Chebukati. Chebukati needs to be out so that we have a fresh election. So that's also going to be another legal pandemonium whereby we'll have to now to go back to court. Remember, if it's a rerun, we'll have to have very limited time. So I'm seeing a situation whereby they might get what they want, if at all they do. Then we also go into another area of going back to court to clarify some other issues. Remember, IBC had a big challenge going into this election because there were a lot of cases to the last minute, which somehow also hindered their process of preparation.
You can't that's scapegoating for IBC.
I'm not speaking for them. I'm not speaking for them, but then I'm trying to also raise an issue which was actually in public domain, because that was very true. That was very true. For us to expect them to do a credible job, they ought to have been given sufficient time to do that.
Wakil,
I'm not saying that they
hear-
didn't.
Another
I'm not
excuse I
saying.
hear from you.
I'm not saying that
what
they
you're
didn't.
telling Kenyans, because Kenyans are watching, let's be fair. Kenyans
Yes.
are watching. You're saying that let's give IBC a thumbs up for the work they did because they had several issues. So even if they didn't give us a credible election, it's
No,
because
I'm not saying
that's
that
what you-
bit.
that's
I'm
what
not
I
saying
hear
that
tonight.
bit that even if
In
it
a
was not
nutshell,
credible.
that's what he's
That's what you're
saying.
telling us, Wakil, and I don't think that's
But
fair
you know,
to Kenyans.
Ken,
Let's
it's
give
not-
an excuse for the
Ken-
IBC. Yeah.
Ken, what I'm saying in simple terms
Yeah.
is we should also be balanced in when we're judging people. We should be balanced. We should actually accept that they try to do, at least on the face value, they try to do a good job. There are mistakes which are bound to happen. Let's scrutinize the mistakes, put them in their perspective. Whoever is culpable, as Dr. is saying, will be dealt with.
Okay.
So that the court also will have its opportunity to make its own decision.
Decisions.
That's
Okay.
what I'm saying.
Sawa,
Can
sawa.
a very big challenge we have in this continent, including Kenya, is that we are tolerating mediocrity in public service for too long. IBC was well resourced. IBC had the opportunity to hire the best people. IBC actually tried to conduct good elections until the officials became compromised, and for details that can only come up in court. What I'm hearing my two brothers here saying is a very good strategy that defense attorneys use. They try to bring confusion where there's none. Also, they say, "Oh, this petition is seeking everything."
It's all over the place.
While we people who have interacted with the petition know what we are seeking. They're also saying, "Oh, DCI and all this, we are trying to look for evidence which we don't have." They have not interacted with our evidence. So the bigger point here, I think, is that, and I've seen a lot of them doing this on Twitter. I'm seeing a lot of panicking by the opposite side because they really don't know. They really don't know our strategy, and in the process trying to confuse the public. But I can assure you that the petition is watertight. The questions have been framed, and if my brother read the petition, then he should have known that we've actually framed the questions, and we're very clear that what we are going to seek from the court is very clear in terms of prayers and everything else. And importantly, we're actually not fighting Chebukati. It's common knowledge that if you've presided over 2 elections that have been controversial, then it's just decent public practice that you exit so that another person is given an opportunity to do that. If we want to remove Chebukati, we know that you have to petition. We know we will follow the law, but that's not our business at the moment. At the moment is that we want the court to side with us, but importantly, then we have fresh elections, or another prayer there is actually that they can declare Azimio candidates as having won. If you look at the data, I'm not sure whether you have interacted with the statistics. We actually can confirm that the statistics that Chebukati read were not accurate. But importantly, let's take one step at a time. At the moment, we are dealing with the petition that must be heard and determined in 14 days. Mm-hmm. If Mr. Chebukati is found to be criminally culpable, then the Supreme Court can just make their finding, but it's not their jurisdiction to punish him. That will have to be taken to the right forum. Mm-hmm. But we can use such a finding to then have grounds for initiating process for removal of Mr. Chebukati and other officers who may have met. It's not really about Chebukati alone.
Okay, I'll read 3 declarations that you're seeking: 13, 14, and 15. Mm-hmm. A declaration B and is hereby made in alternative to 12. I'll not go to 12 above, that the presidential election held on the 9th of August was not conducted in accordance with the Constitution and applicable law, rendering the declared results invalid, null and void. 14, a declaration be and is hereby made that the the ninth respondent did not meet the constitutional threshold of attaining more than 50% plus 1 of the votes cast. The 15, declaration be and hereby made that the 9th respondent was not validly declared as president-elect, and the declaration made on the 15th August is invalid, null and void. I'll go to 14. What is the I see a mischief with this, or I see a little confusion with this. When you go and say he did not receive more than 50% plus 1, what are you talking about? I mean, what are you talking about? You're simply saying he did not achieve it. And if you look at 2, 3 there, you're asking to audit even the KEM system to determine this, but
which process can be done within the
I'm not sure you've interacted with Okia Omotata's petition.
Which one?
The one is filed today.
I've read it.
If you've read it, he's actually gone to more details to get us the numbers,
Okay.
and question whether there was a candidate who achieved 50+1. So there's a more technical component of the petition that I'm very sure details will come out during the hearing. But all available evidence is pointing towards one direction, that no candidate achieved 50+1, and that the numbers were massaged to favor a particular candidate. And this was done in a very systematic way across the country, particularly the so-called strongholds. But data is data. If
numbers don't lie.
Yeah, numbers don't lie. So if we say that somebody did achieve 50+1, then we should be able to prove it statistically.
He who alleges,
and that's what that prayer is really
about. I read another one, but let me hear your comment on that.
Okay, mine is Komolo seems to have already interacted with the evidence and has become the judge and is already concluding this thing. It's unfortunate that we have not interacted with the kind of evidence he has interacted. In the hindsight of that, I would want to say that, you see, this particular petition is a very interesting one because it comes at a very interesting juncture, where they claim the ref should not be the one who should have refed. Anyway, he went ahead and refed, and now they're saying this guy, we don't need him.
Where is that?
I mean, from what he's saying, Ken.
But I just told you this is a very common practice about that defense attorneys.
I'm coming to you, but
be very fair.
Also be fair to us. I
haven't
heard that.
He went ahead and said that.
Look, they're trying to put confusion in our petition. There's no confusion in the petition.
To be honest, I haven't heard that. They're pulling Chebukati towards the end, not from the beginning, because I haven't heard them say that the ref is not the one who should have refed, but he still went ahead.
That's what we started from the 2017 on, where you started asking.
You've gone back to 2017.
Yes, that's where you started asking. How come we ended up with the guy?
I thought it was canvassed in this.
No, I haven't said that. I haven't said that. You see,
I've just
it's you being unfair to me.
Go ahead, Wakili.
So what I'm actually looking at is a situation whereby we actually should be having this discussion next Monday when the Kenya Kwanza filed their defense, so that we are at par. Now, we have Komolu has interacted with the evidence.
They must respond by Thursday, 4 days, right?
What I would propose is that you ensure we come back together.
Yes,
once they have responded.
But you'll be in court.
No, we can create time.
We can create time and come and deal with this, because now this is actually my boss.
I know they are watching.
This is becoming very
okay,
we are beating one side too much at the expense of evidence which has not been accused. It's always you will always listen to one side and believe what they say till the other side says or comes up with their story. So that's what actually I'm trying to say. That
Monday it is.
Yes,
Monday it is.
Yes. So that we can be able to converse some of these issues conclusively. So that, but I hope we will not turn this into a court. Because the way we are going, we need a judge. We need a judge, and we might give a judgment already. Yeah, so I think what he's saying, if whatever evidence they claim to be having, we will wait and see, and the court will be able to determine. There's nobody else who is accusing the court not to be competent, so we just wait and see. Having said that, then we also need to also be very fair. Because Ken and Komolo, I'm seeing a relationship whereby you're letting Komolo on for too long.
No. If you're not making your point, I'll have to get another point. So proceed.
This is very unfortunate because, I know my brother's political side has been complaining about the media taking sides and things like this. Look, we are dealing with the petition. Let's focus on the law and the evidence and give the judges time to.
He's already complaining that you're speaking too much.
He's imputing improper motives on your part.
It's okay. I can handle that. Zach is quiet.
Maybe I'm the mediator. It's my time. I'm giving them enough time. Yeah. Ken, the scriptures tell us in the book of Proverbs, the accuser is always not right until the accused gives his response.
Exactly.
We have not had a response from Kenya Kwanza. and I need to emphasize, they need not to say anything. Because even on the face of it, what is before the court is an application which is in the form of a petition, and the doctrine which I said before, who alleges must prove, lies on the onus on the person who has presented it. So on the burden of proof, remember, it is on Azimio to impel the court that the election was not free and fair. It's not for Kenya Kwanza to justify their win. I think that one should go on record very clearly. Because there is a rebuttable presumption of law that the arbiter who was the referee, Chairman Wafula Chebukati, and the commission as it is at, and as it is or it was then, was properly constituted, and the pronouncement they gave was in compliance of Section 83 of the Elections Act and in conformity of Article 88 of the Constitution, which behooves them that mandate as the IEBC. So on the face of it, it is not the duty of Kenya Kwanza to justify how they won. It is the duty of Azimio to prove
that they did not win fairly.
That they did not win fairly, or why that thing should be vacated.
But let me ask you, just on that, what happens, let me say, for example, because he says they've even have proof of Form 34 is that were altered that have different serial numbers, right? So if they produce the two to show that, when you say whoever alleges must prove, what happens? Can Kenya Kwanza side also come with their own Form 34s and say, this is it, because they are certified, right? So they certify theirs, the IBC certifies them. And remember, when you are doing the procurement, one of the set of documents you require is sort of a checklist of the materials you're bringing. So if I'm bringing 34As, right, then 34As serial number running from 001 to 2000 are here, so I can check. And this is the watermarks. So when you talk about whoever alleges must prove, so what happens then if they have contrary evidence against them? You're telling us today they can't produce their own?
What I'm saying is, in as much as you have presented the evidence, you have the honors to rebut and reply to that evidence. And the question is which evidence is more believable to be taken. If they have competing documents, then Kenya Kwanza, I think, also have the response to that extent. But in a quick succession of that particular answer, if you can easily foretell the future by having a flashback and to look at what was happened in the past. Remember, we have been having this narrative that they also had run a very competent tallying center, which was not known to the public. It seemed like a very high-end NASA facility, which was unknown. And the truth is that there was no such kind of facility. So when we are told that they have interacted with this particular evidence, I think it also behooves us to ask ourselves at what juncture this so-called big evidence will be presented in court.
Okay.
So that even if we had no privity of being the drafters of this particular petition, at least on my own end, and I think on the end of most landed councils and the people who are before you today, we had to have a chance to look at it. And I would have wished if that evidence was actually properly before the court, so that we'd be interrogating it and actually asking ourselves whether it meets the threshold applicable, but not being told somehow in the fullness of time, we know we have a very strong case, it will be presented somehow. At what level? Because there is none.
The evidence already before the court, properly filed today. I am aware that the respondents have been served or are in the process of being served within the timelines. It's clear to me that my brothers are not part of those who are supposed to be served, so we're still speculating here on whether the evidence is tight or not. But it's also clear to me that, for example, if we prove the numbers are not right and we are able to bring Form 34As that are compromised and all that, then they have to respond.
Yeah, with authentic forms.
With their version of authentic forms.
Okay.
Yeah, that's what trial is all about. So let's wait. I'm looking forward to. And by the way, they told us to get them from the portal.
I'm of the contrary view. We're kind of interject, and I know he's on his feet. Remember, the forms that are already on record, there is a rebuttable presumption that those forms are properly constituted and they form part of the record, and that's what gave rise to that kind of a pronouncement of the president-elect as we know him today. So it's their honors now to show us that those forms or any contrary evidence that they have is cogent enough to vacate that position.
But on the basis of forms that were falsified in 2017 that the election was largely nullified. I remember Maraga. It was on the basis of forgeries that they were nullified.
Maraga's question was about the process, how it was attained.
The whole process. That was the whole thing.
And they refused to bring them to open the server.
If the process is found to have vitiated from what could actually violate a free, fair, and fair process, in spite of an outcome being presumed good, because the process was bad or compromised, so it invalidates the entire exercise.
Okay.
And I think that should not be lost.
Okay.
Yes. I think I will tend to agree with Njage here, because the basic principles of law are that if you allege, you prove. But in a situation where you can't be able to prove, you shouldn't say, no, I can't be able to prove this because so and so has my evidence, need to be assisted with this evidence so that I can be able to prove my case. But that is a story which Komolo seems to be defending himself so much on. But to the aspect that he has been able to interact with his evidence, which we haven't, we should actually be given time to interact with it, and then we'll be able to prefer our case. At the point that we will be able, the Kenya Kwanza side will be able to file the evidence, we will be having a different discussion that time round, because we will have an enriched discussion on which he seems to say that he has some forms which are adulterated. I don't know where he got them.
I've not said that.
Or some forms which are not actually complying with the procedures. We want to see those forms, and then the Kenya Kwanza side will be able to be given a chance to also bring whatever it is that they claim or they feel should have been a mischief on their part, because remember, that has not been brought to the fore. Once that has been brought to the fore, then we can be able to interrogate all these issues at once. In addition to what Wakili has said, I think that is a very fair way to proceed.
Unless you want, we have a few minutes, and I need to really ask this question. 19, 20, and 21, and this is based on the chairman of the commission. A declaration and is hereby made. The second respondent is unfit to hold public office. A further declaration is hereby made. The respondent is a breach of authority. All that. I know you've all seen this petition. My question is this: there's a pronouncement, and I'm not in anyway, I should say, they call them that. I'm not predicting the outcome of this court. But I just want to understand what happens on that day when a pronouncement is made and Wafula Chebukati is found to have acted beyond his powers or something like that. And then, if you look at this petition, they have actually sued everyone. Do we consider Wafula Chebukati in isolation because he's been named right at the top and they're going for him on 19, 20, and 21? Or do we consider a whole commission? And if we consider a whole commission, what happens to a fresh election if at all it's ordered?
Individual culpability. So if the Supreme Court grants that prayer, then it follows that the process of removal of office under Chapter 15 takes in. So the process of removing the chair, that declaration is specific to the chair. Remember the commission, when we were last here, we discussed that the commission is already divided, and the commissioners are respondents in their own rights. So at a particular point, they will have to take individual responsibility, and I'm really waiting to see their response, because we know 4 of them have taken a different stand from the other 2 or 3, and that will go to confirm.
Can they do one affidavit and each of them sign?
That to me is their choice, but when you are sued as a respondent, then you need to ensure that you put your reply affidavit.
We all agree, so let's have one.
Yeah, so let's not overemphasize, just as I mentioned earlier, let's not overemphasize the process of removing Chebukati. Chebukati is a public officer with conscience, and he should by now know that if elections have been nullified, if this one succeeds, have been nullified twice under his watch, then the right thing to do is to step aside.
I don't want to talk about Chebukati much because he's blocked me today. I don't know why. I don't know, Chairman. Why did he block me?
Thing.
I don't know why he's blocked me.
Well,
But
I think the bigger point is that it will not be practical for Mr. Chebukati to preside over fresh
a repeat election.
repeat elections,
Okay.
and we will deal with that once we are done with the Supreme Court.
Okay. So what happens in your view? What happens in case they found that, of course, he's in the wrong, as action needs to be taken, and we have to do a fresh election within 30 days?
60 days.
60 days, sorry, Article 138. What happens then to this commission? In case all of them are indicted, by the way, because they are all commission. If you look at the definition in the IBC Act, they are all part of the commission. What happens to us as a country?
The Elections Act number 4 of 2011 is very clear that the commission is a body corporate, just like an organ or like a company, so that all commissioners, through the chairperson, is the first among equals. It just like in any organization, you may have a consensus whereby all of you agree, or you could have a quorum in terms of the test applicable. And I think the quorum has been answered sufficiently by the Supreme Court during the question about PBI of what is the minimum threshold for such kind of an action to be taken. In regard to the Chebukati question or the chairperson question, I think we should also look at it in a more detailed way, the extent of such kind of invalidity, which you asked if he's found maybe to have done things beyond his powers, or maybe found to have done things that are not in conformity with the Constitution and the law. The extent of that kind of a pronouncement or a finding towards the entire process of the 2022 general elections, because it's very difficult to draw a clear line on the sand between what he did as a presidential returning officer and where the duty of care lies to also the other candidates. So that in as much as we look at it in a very straight, clear eye in terms of the presidential question, also the whole validity of the whole election would actually be put into a great test towards that particular process, because the extent should also be very clear, the extent of that culpability. And because the question about being ultra biased, I think that's what you asked, acting beyond your powers or acting illegally, should also not invalidate what you acted lawfully. So that to give a very blanket condemnation would not be in the interest of the person or in conformity with the law and practice.
Okay.
I think for me, with all fairness, is to say that in the event that Chebukati and the commission are found to be culpable, depending on what the Supreme Court finds, then of course the law is very clear on what it is that should be able to take after, whereby the process of removal and bringing on other people on board. But my challenge is whether that will be able to be enough time for us to have enough people to come on board to conduct another fresh election, because that's going to be that's what I was trying to allude to earlier, that we're going to have another series of circles in court, and we might not be able to achieve the constitutional timeline of 60 days to do a fresh election. Even if you bring some new people on board, then these people need to be oriented.
Yeah.
They need to be oriented. They need to be brought up to
speed.
speed.
6 months.
Yes,
It's
a tedious process.
Let
So we should be able to also look at the perspective. I don't know whether the court will consider that, but that is a subject of the court to decide. We cannot be able to speak for the court. But what is of essence here is, if the Kenya Kwanza petition is as solid as Daktari says, it's all the Azimio side, we can be able to actually wait and see, because now we can only be guessing.
Let me ask you, Wakili, that constitutional timeline, is it, which one is strict? The second Tuesday of August, or the additional 30 days if it's a rerun, or additional 60 days? Which one is the law very strict on? Because we can say the law can vary. Is it just strict on the first one, because the first one now determines when the second one happens in case of a runoff, and a repeat election in case they have to go for a re-election? So is the law really strict in the following timelines, or is only strict on the first one? Because the first one determines the reason why I'm asking this is just in case we don't have the commissioners. if you look at the period with which they have to be in office before they can run an election, also determines. So, for example, and you said he's a first among equals, but he's higher than all the rest of the commissioners, right? So, what happens here? I don't know, honestly, what happens. Are we strict on that timeline, or there's a way it can be extended, or even, I don't know. Is it possible?
I wouldn't be able to authoritatively answer you that, Ken, but what I'm looking at is a situation, depending, looking at the petition which has been filed today, I think there is a sense in which it tries to speak to the chairman strictly, that is the one who should be able to be looked at more than the other commissioners. You remember the other four already, they were giving their statement on the side, and I think their party is, in a way, they're trying to also bring their case on board to say that we didn't agree with this. It was very opaque. We don't agree with these issues. So there is a sense in which I see the petition trying to point more fingers at the chairman, so that once the chairman is out, then of course the other commissioners
can he pull that responsibility of a chairman, the vice chairman who does not have the same qualification as the chairman? Can they pull up? Can they take that responsibility up?
That is now going to be the challenge, and that has got to be will need to be even be tested up to the court level, and that's going to be a very big problem.
Big challenge. Okay.
Yeah, so just to answer you on the timelines, yes, the timelines are cast on stone.
Oh, they're cast on. Okay.
Yeah, and it's clear that if it's fresh elections, it's 60 days. If there's rerun, 30 days, and regular elections, second Tuesday of August every 5 years. So that's the beauty of the Kenyan system in terms of the constitution, because things are predictable, including dispute resolution and all this. Talking of the point you've been discussing over the last 5 minutes or so, nobody has filed a petition to remove commissioners. I've not interacted with, there are about 9, I've interacted with about 4 or 5. Once you start reading the third one, you realize they're more or less the same in terms of the arguments and what they're seeking. So nobody in those petitions, nobody is trying to remove the commissioners. Okay. Well, but everyone is pointing an accusing finger at Mr. Chebukati, particularly how he handled the last
based on what the folks said.
And of course in his capacity as returning officer at the national level. So if it gets to a point where Mr. Chebukati has to then leave and not preside over the fresh elections if they are to be ordered, then logically the commission will gazette another presidential returning officer. That's a basic question. A basic question of necessity.
Among them?
Yes, even the vice chair can be
without the qualification of a chairperson.
Yes, basic necessity.
Because
necessity. I mean, how then do you recruit a new chair in 60 days?
Okay.
And the commission, remember, works as an entity. So it's in fact, I think that's where Mr. Chebukati got it wrong, because it didn't seem to have worked with them in a collegial manner, so that they
don't specifically demand the qualification of a chairperson.
Yes, but
the law is separate from the rest. How do you just say now Ken Mijungu, who is not qualified to be a judge, or will just do this?
But the law,
purposes of the election and being a necessity.
The law also anticipates that the chair could be incapacitated, the chair could be out of office, the chair can also pass on.
Yeah.
So if the chair passes on 2 days to elections, we don't have results announced.
Well, our law, our law does not.
So the administrative qualifications, those are understandable because he has additional responsibilities. But we are talking of managing an election, which is a corporate function of the IEBC.
Yeah.
And in case 1 or 2 staff will not be there, then of course they can be replaced. For your information, here in Embakasi is the returning officer passed on, and the deputy announced the results.
Okay.
I think Ken, before you
we need to go. Yes.
There is a sense in which, as I was saying, that the only person who is wanted out is the chairman, so that for some reason somebody else is gazetted.
Speculation.
Somebody else is gazetted, so that they conduct this election.
Yeah.
Because I mean that's what the petition seems to be speaking. Yeah, that's what I'm trying to read into.
Yeah.
And once that is done, then of course whoever was drafting this petition was very careful and very technical, and they knew what they were doing.
Thank you. Now at least recognize their talent.
And which these people are trying to basically they're not speaking directly to the chairman, but they're playing all the play. Yes.
Okay.
So that somebody comes on.
Gentlemen, we have to end, and my director is on my ear so much, but I'll give you 30 seconds to conclude. And because you finished, or let me start from you. Tell me, is there a way, in 30 seconds, tafadhali, is there a way if they find that there were wrongs that were committed, right? But even if they corrected the wrongs, for example, they would not invalidate this election. Would they still invalidate the election, or they can say these are administrative issues, so we can't invalidate? Even if they altered, William Ruto will still be ahead. What will happen? Just in 30 seconds, in your opinion.
The Constitution, I think it's Article 140, anticipates the Supreme Court to either confirm or annul and organize and order fresh elections. I've seen people commenting about the Elections Act and whether the Supreme Court can then declare one person or the other to have won, even if it's not the one they call president-elect. But to my mind, I think that there are only two options: either confirm or nullify and order fresh elections in 60 days.
Okay.
Yes.
You can only confirm or order for fresh election.
That's my reading of Article 140.
140, yeah.
And by the way, we don't want a situation where courts elect our public officials.
Yeah.
We want to be able to elect the president.
Wakili.
The framers of our constitution had envisaged a situation whereby state officers would be intimidated or they found hindrances to conduct their official duties. And that's why they brought the question about security of tenure, which is supposed to act as a shield but not as a sword to protect them from arbitrary removal from office or from such kind of enterprise which would intimidate them to that particular kind of an action. When you're told that the commissioners can arbitrarily sit and appoint one of their own, it defeats purpose of why a security of tenure would be there for the chair. And I think that is one of the questions that was because it had envisaged a situation whereby not everybody would be happy. I need to emphasize that the role of the opposition is also envisaged in a constitution, in our law, so that that kind of office should actually be looked into an office for purposes of checks and balances in terms of fair administrative justice and conducting of our governance. In closure, I think why on the considered view that as a democracy we've really grown, you've seen that these questions that are being brought, they are being brought in the corridors of justice, and that is why we should be channeling our dispute resolution for purposes of posterity and the growth of our republic.
Okay, well said.
Yes, for me, Ken, it's first to congratulate the Azimio side for filing the petition
In time.
Yes, in time. And secondly, I anticipated a petition because there's some gray areas which have come up during this election. We need them sealed, and I think I've seen them speak to those effects. So we'll be able to see that in the next election, you remember even the Maina Kiai case helped us because we had a fair, almost a fair, transparent election. We need to see that calculated in the general elections to come, so that we don't find ourselves in a backward situation. But then just to close is the aspect of the chairman. From where I stand is where we can actually put it that if you want to kill a dog, give it first a very bad name, so that's when you kill it, you say it's already had a bad name.
Exactly. Well said. And that bad name started in 2017.
And I was blocked you on Twitter.
Yes. Thank you so much for coming tonight, Gibson Gisore. Advocate, thank you so much. Peter Njagi, asante sana kwa kuja. And of course, Eric Omolo.
Yes.
Free pass. I'm talking to my boss. I know they are watching.
Yes.
Next week on Monday, once the evidence is stable, we can now argue the probate value of the evidence presented by each. But I just add one person on the table to balance, because today it was so imbalanced. But I want to thank you for coming tonight, and on behalf of the whole team, Meresha Owiti Aleron on sign language. Have a good night. Let's do this again on Wednesday. I'll be back with news. Remember, the Supreme Petition begins proper with the filing of the case today by Azimio Moja, led by Raila Odinga. Have a good night. God bless. My name is Ken Mijungu, and see you on Kivumbi 2022 next week. But Wednesday, make a date. I'll be right here.